live after a long time now. Today this live is only for members, member only live. I will try to answer the members' questions. So now the format has changed. All the membership options. I won't be replying anything via comments, only through lives. The lives will happen at least once a week and maybe more frequently as I have time. So any members, they can ask the questions on any comments and I will answer them during a live session. If you are unable to attend this live, YouTube usually saves this live, I'm pretty sure. You can watch it in your own time. I will mark the live as an answer to your question. So one of the questions I have, let's take the questions. So first from Mohammed, understanding IHS refunds. Okay, thank you very much, Mohammed. You have given me all those, I think, partitions or whatever they call it through Merlin AI. Thank you very much for doing that. So Mohammed Darman 2567, thank you very much for showing me that Merlin AI, how it gives me different headings for my videos. Thank you for that. Okay, next question, Dilatronic. If my company can't provide cost before my visa expires, what will happen? They are sponsoring me, but if they provide the cost after my visa expires, would I need to leave the country and apply for the skilled worker visa from outside the UK rather than applying from within the UK? Yes, if your visa expires before you file an application, I think getting a cost is not that much of an issue. So one of the options you can do is, so the question is about his visa is going to expire, company has not got a cost, so they cannot assign it. So very simple problem. It is a common problem. Home Office is aware of this. Sometimes we deal with many of these sponsor license applications for employers. So this is a common issue that I have seen where we file an application. The employer may not get a priority service for sponsor license and they may have to wait for 8 weeks and at least that much. Or even if they have a license and they apply for allocation, allocations will take about 18 weeks. That is still the current standard, and priority slots are quite difficult to get. So this is a common fix that many employers, migrants are in a so I'll just try to answer it across for everyone. So if your visa is due to expire, so one of the options that we try is we file an application. Usually you should do this through only through a legal representative. It's a very tricky one. Home Office may declare the application as invalid because having a cost, etc., is a part of validity rules in the immigration rules. So Raj Singh, yeah, you are a member. I'll take your question. Just 1 minute, I'll answer this. So you can file a skilled worker application pending the cost, provided you know that you are going to get a cost in a reasonable time. So, and then once you get the cost, you can send it to Home Office. This is usually done by legal representatives. We do it many times. So that is what my suggestion is. If you don't get the cost and your visa is expiring, yes, you should leave the UK. And when you make an entry clearance application, you will have to get a DCOS, defined certificate. On the contrary, if you file the application inside UK, you can do it with the U cost, undefined cost. So you know the difference. So Raj Singh, your question is, my fee waiver was rejected and I have overstayed 2 days today. Can I still apply for skilled worker visa or shall I file FLR? So if you have a cost and when you say you have overstayed 2 days, so is it after the refusal of the fee waiver, you have 10 days to apply? So 10 working days. So if it is more than those 10 days, then yes, your application may not be considered from inside the UK. But if it is just 2 days after the refusal of the fee waiver, you do have 10 days to apply, make a paid application, any application rather. So yes, if you are within the 2 days, so if I'm assuming that your fee waiver was refused just 2 days back, then yes, you can apply within 10 working days of the refusal of the fee waiver, any application, whichever you are eligible for. So if you have a skilled workers sponsor life, you are getting a course, etc., yes, you can go for it. But the filing an FLR does not help much. It is something that I am always advised against. Home Office is not happy with it. There are weird implications of that. So you can see the video on fee waiver and FLR applications. I think buying time, it will not help. Unless you have some basis, only then apply. That's my suggestion. Okay, M. If my wife has officially finished her degree and she wants to switch from a student visa to a dependent visa, but her official letter has not yet come out, shall we wait or shall she apply now? She can apply now provided her course end date has completed. So if her course end date has passed, even if she has failed in the course, it doesn't matter. That's cleared by home office now, so you don't have to successfully complete the course in order to switch into some other category. You just have to complete the course, which means she has attended her university, done everything that the university asked, the compliances of the uni. So one of the suggestions that I may have is, just if the results are not yet out, you only have the CAS letter which shows your end date of the course. That's one you can use. With that, one additional thing is, if you go ask the university, just get a letter from them saying, we confirm that this applicant has completed the course of study. They may not say successfully, or that doesn't matter, but that will be helpful. If not, at least with the CAS, yes, she can switch because the course end date has passed. That is, as I'm speaking strictly as per the immigration rules here. So yes, it is possible for her to switch. Okay, I've answered the electronics question, so that one is done. I'll take the next one. So will finish the degree and she wants to switch. So visa dependent visa official letter has not yet come out. She wait for in this case that she need to wait for official letter to come. Okay, I think you asked the same question, so I have addressed that on the channel as well. You have asked. Let me delete this one. Okay, remove. Just ask the question on any one question. I know, I think you have mentioned it on several questions over here. I have to just delete them, so it's unnecessary noise in the system. Okay, remove. Okay, 1, 2, and 3 I've answered this. If any member is coming live, they can ask questions, or I'm going on to members' other questions which they may have replied. Responses with new replies. Okay. So how long does it? So there are some questions from members which I may have answered. I'll just clarify on some of those answers. How long does it typically take for a company to obtain a costs? For undefined costs, if they're applying for allocations, 18 weeks is the processing time as of now, standard. And priority slot is very difficult. There are only 60 slots in a day. And if you get priority, it's decided in 5 working days. So that is all about undefined costs. For defined costs, standard, so there are home offices bifurcating the industries into different parts. We have different types of industries. For example, IT and all, they are quite low risk. I've seen that many times. I get the course on the next day, defined certificates of sponsorship, where it is a reasonably highly paid job, something over 50,000 at least. All those salaries which are over 50K and all, I've always seen they come within a week on a higher end, sometimes even the next day. But if your salary, so there are two components that I have seen as an experience, as a matter of experience, and also whatever we hear from home office. So some of the industries, like whatever social care work, building industries, retail, hotels, etc., etc. So all these industries, and usually home office does take more time to research on them. So anything between 1 month to 3 months, they will ask for extra information, etc., etc. That's what happens. So that is the cost timings. Next question. So you are an engineer. It really depends what is that the salaries are. Uh, this is what I would bifurcate. If it is anything between on the baselines, which you are trying to get a skilled new entrant visa or something, 30,000 to 40,000 or something, those like that, they may take time depending on the industry. It really depends on various factors. Some of the things that home office pointed out in the last sponsor license, yeah, we had a meeting, I think just in the last 1 month or so, through Immigration Lawyers Association, and it depends on how the employer is behaving. If they just have 2 employees and suddenly they ask for 10 certificates, they are going to audit them. They are going to take them left, right, center and check everything. So that depends, though that is one of the factor where it may take more time, up to 3 months or so. So Raj Singh, your question is, I have overstayed 2 days after 10 days period of rejection. What options do I have? you should leave the UK. I think beyond that, even if you make an application, most probably it will be considered as out of time, and they may just reject it as invalid. So that's I have to speak strictly honest, but immigration rules. That's what it is. In question where asks about driving license. Yeah. So one important thing: this channel membership or lives and all these are not for application questions. As a matter of good just goodwill, I have answered some of the questions on the channel. This channel is not to answer questions on the application form. I just give some answers here and there, but I see that some members are asking a lot of questions, the whole application rather. So you should speak to an immigration lawyer. I will try and answer this one, but please don't ask me application question forms here. I cannot fill your whole application on these lives or anyway. So in question where asked about driving license, I only included the number 68 without the extra 2 digits. That indicates that the issue is now is fine. Yeah, that is perfectly fine. Yeah, but please don't. I'm not going to deal with application questions on lives, etc. So you should speak to an immigration lawyer, get the application reviewed, etc. Because one question on its own may not make sense many times. The whole application should be looked at together. Yeah. So I don't get calls before visa expires. Yeah. Yeah, if you don't get a cause before your visa expires, you will have to leave the country. So, the electronic. Next question from a member. This is done. This is done. This one is done. I will be live for about next 10 to 15 more minutes. Okay. Next question I have from a member is thank you. Yes, I think I've answered this one. Okay, so the next question I have is I received my costs straight out NMA 6205. I received my costs on 2nd April 2024 for a shortage job on shortage occupation list. I wanted to confirm if I'm eligible to have a supplementary job under 20 hours a week in any skilled job. Yes, you can. If you get a skilled worker visa, doesn't matter even if it is shortage occupation or not, any skilled worker visa for that matter, you can do 20 hours in any skilled job which is on the skilled occupations list on Home Office website. Also wanted to understand if there is a possibility to register as a sole trader and of being actively involved in your own business without creating it any conflicts. I would strongly advise against registering your own businesses. This is something Home Office always shies away from answering. I've always seen any times we ask them, and they have a usually they have a no. That's what I've seen from any seniors that we have spoken to on any of our forums with Home Office, because the main argument that Home Office has is there are work time regulations, how many hours you are working. There are different laws in the UK. That's one part of it. Secondly, they are unable to monitor you how long you are really going to work in your self-employment. Doesn't matter whether that is registering a company, any setup, you have a separate legal entity or you are a sole trader, doesn't matter. So again, I would always advise against self-employment unless you are on a specific type of a skilled worker visa. For example, you are a dentist. I know that there are some categories like dentist, etc., where self-employment, the skilled worker visa itself allows self-employment. That's a completely niche area. It's a very very small area, less than 1%. Usually with skilled worker visas, you should not do self-employment, whether sole trader or anything. I don't care what the setup is, partnership or anything else. So the main reason Home Office says is they cannot monitor the number of hours that you will be working on that particular project of yours, whatever that is, startup, etc. And it does make sense. If you have very strong reasons and you are able to prove at the point of ILR, if the Home Office challenges and asks you questions on your self-employment, you can 100% prove that I only worked within the limitations, 20 hours within a week. Then yes, you can take the risk, but the onus will be on you to prove. So next question. Okay, this one is answered. Okay. Okay, one of the questions, Silva 7008 said is, thank you, I failed to scan my current BRP on the app, UK Immigration ID Check app, and I went through the filing application without ID check. Okay, I hope UK Vikas will do this. Yeah, if you are going through, if you are not going through the app for any application, whether it's graduate route or skilled worker or anything, if you decide for any reason you are not using the app, if you go through the application process, you can upload the copy of the BRP while you're uploading the documents, number one, and or you can take it to the UK because UK Vikas has become TLS now, so TLS has got the contract. So you can take it to TLS and ask them to scan it. They will charge you for that scanning and all. So that is always possible. Next question. Okay, the next question, that question on question. How long am I required to stay with my company after they provide? For example, am I allowed to leave after 6 months to join another company? You can leave the company that has sponsored you at any time. Whatever the company has signed with you for repaying all the costs and all, that's a different matter. That's a contract dispute that you have to take care of. But under the immigration rules, you can change the company. You get a visa today, tomorrow you get another company, you can switch. Home office doesn't stop you from doing this. So the rules don't stop you. And I think further you have asked me, Dilatronic, isn't, are you sure? Yeah, whenever I say something, I am sure. Okay, so I'm talking from immigration rules. I'm not just messing around with you guys. Isn't there a requirement to stay with the company for at least 1 year? There is no such thing in the immigration rules that requires you to stay with the company for 1 year. Could that be something that the company sets as a condition? Yes, the company can set as a condition, but they cannot stop you from. I at least know, I cannot advise on employment law, but I know what employment rules are, employment laws are. So they cannot stop you from changing employment, but they may ask you to recover the costs, etc. So they may ask you to pay the cost of the visa fees, etc., depending on what was agreed with you at the time of employment when you entered into all the contracts and signed them. So yeah, they cannot stop you from going, but they can ask for compensation for any cost that they have incurred on training, visas, etc. So that is always possible. Okay, I would like to have your opinions. Okay, I gave that opinion. Okay, thank you. Can you put this answer? Thank you very much, Andrew. We got the answer. Uh, okay. Several questions on absences requirement for ILR. So just to summarize, this is a common question. I have that several videos on that. I think for the skilled worker indefinite leave to remain, if you're applying, you don't need confirmation of your absences from your employers. This was a requirement in the previous rules when it was tier 2 general. As soon as when it became skilled worker, that requirement has been taken off. So that is to summarily answer. Now I think specific questions Andrew, the member, has asked. I just subscribed. I have three questions. Do we still need to state the dates of absence in the application? Yes, you need to state the dates of absences in the application because Home Office will, though they are not asking for a confirmation from the employer, you still need to meet the requirements of not more than 180 days outside the UK in any 12-month cycle. That's the residence requirement. It appears you can only input 30 absences. Yes, you can only input 30 absences on the application form, on any application form rather. But you can add the additional absences as a sheet and upload it on the TLS website. So that is perfectly fine. If I am required to input also extra absences, you should just write it in an Excel sheet in the same format: date left, date returned, country visited, reason for absence, tourism, visiting family, anything, work, and number of days absence if that is also there. So yes, you can attach the spreadsheet. So that is my answer. Let's take another one. Okay, the electronic. I need only need obtain certification from the company. Yes, when you file for the skilled worker application, and if you are switching usually from a graduate route, you are already meeting the financial requirement for the skilled worker. You only need the cost mainly. You already meet the English language. You only meet the already meet the financial. So if you are switching from graduate route visa or already on a skilled worker visa, you are switching companies, then in that case, you only need the cost from the employer and some information like their sponsor license number, etc. If I engage in work for another company or startup for 20 hours or more, am I required to inform the company that is sponsoring me as a skilled worker? Ideally, your employment contract will require you to tell them. That's what standard employment contracts are. Firstly, employees are not allowed to work. I think there is some restriction. It depends on employers. And if you are allowed, make sure your employment policies of the company allow it. Immigration rules don't stop you, but so the question is, if you work the 20 hours with someone else, some other company, am I required to tell the main sponsor? There is no such requirement as per the immigration rules, but your employment contracts may require it. So then let's answer next question. My UK PSW visa expired on June 20. Will I be able to apply for school under new entrant category? Yeah, so Amrish, his graduate route already expired 29 July. He went back to India. He's asking me, can he apply under the new entrant category? Yes, this is a common question. People don't know about this, so I'll just explain it. From the end date of your graduate route visa, you have up to 2 years to apply for a new entrant visa, even if you leave the UK. So in this case, Amrish has gone back to India. He didn't get any employer till the end date of his graduate route visa. He left. So that's why we always say, when Home Office says leave the UK, if you don't have a sponsor, don't have any options, go back, find employment, and within 2 years, if you left on your last visa was graduate route, you leave the UK before the expiry of that visa, or last date of the visa, you leave the UK, then you can apply for the new entrant category even from India, even from outside UK. Yes, you can, up to 2 years after the expiry date of that visa. So remember that it is allowed under the new entrant category. So the new entrant benefit still remains. Okay, I'll take maybe one more question. I'm facing issue with my employer. If my employer loses his sponsor license due to non-payment of salaries, if I don't find another sponsor, where can I go for FLR? Yeah, as I always said, filing applications to buy time, I would always advise against them, unless you really have something concrete lined up within 2-3 months, something is going to happen, or within a reasonable time. But just filing FLR application for the leave to remain without having anything and telling Home Office I just want visa for no reason, I don't think that is something that I would advise. I always advise against that. Or even just filing fee waiver application, because it doesn't need any fees to be paid. Just file that application. Fee waiver application is not even an immigration application. I've explained that in my detailed video about the fee waiver trap. So that is what I would suggest. Unless you have something concrete, you should leave the UK. That's my best advice. I know people don't want to take it. I have to tell you what the immigration rules say, and as a lawyer, I can only tell you what is right. So you may not like the answer, but that is the answer. Okay, so let's check this one. Okay, so these are all the questions that I have taken. So the previous, you can become any member and join any of these member lives. I will try to do them at least once a week. I will do that um, as soon as I have some time. I may do more lives as well, and try and answer any questions. All the So the membership model has changed now. Please understand, if you are become a member, if you don't want to be a member, you can cancel. It doesn't matter. Everything majorly goes to YouTube and to charity only. So if you want to become a member, the questions of members will only be answered during live sessions like these. And yes, you may have to watch this video either live or it will be saved on YouTube. You can watch it in your own time. So that is how the membership options will work from going forward onwards. And thank you very much anyone who joined live, and thank you very much who will watch this live afterwards.